The Honorable, the Chief Justice of the Republic of the Philippines, the Senior Associate Justice, and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
Please be seated.
Madam Clerk of Court, please call the cases before us.
Good morning, Your Honors. Scheduled for today's oral arguments are the consolidated petitions in GR number 271059, Representative Edsel C. Lagman et al. Versus the Congress of the Philippines et al. GR number 271347, Aquilino Coco Pimentel III and Pantaleon Bebot Alvarez versus Lucas P. Bersamin in his capacity as Executive Secretary et al. GR number E-02472, Filipinos for Peace, Justice, and Progress Movement Incorporated, or FPJPM, as represented by its President and Chairperson, Joseph Cadsawan, and Chapter Officer, Gloria Puzon, versus House of Representatives et al., and GR number E-04036, Edgar Erice and Laila de Lima versus the Senate of the Philippines et al. Thank you, Your Honor.
Appearances, please.
For petitioners Lagman et al., Attorney Lorenzo Artañaga, and Attorney Barameda.
Good morning, Your Honors. I'm Attorney Elmar C. Barreda of the Lagman Law Offices, and I am respectfully entering my appearance as counsel for the petitioners in GR number 271059, Your Honors, please. Thank you, Your Honors.
Good morning, Your Honor. Jericho Salenga appearing as counsel for petitioners Aquilino Coco Pimentel III and Pantaleon Bebot Alvarez. Good morning.
Good morning, Your Honors. I'm Attorney Joseph Lemel Baligod Bakiran, respectfully appearing as counsel for petitioners FPJPM with Attorney Relene Arellano, Your Honor. Thank you.
Good morning, Your Honors. Attorney Renelyn Arellano for petitioner FPJPM.
We file the manifestation. We request to file.
Chief Justice Alexander Esmundo, Senior Associate Justice Marvic MVF Leon, and Honorable Associate Justices of the Supreme Court, good morning. I'm Attorney Vopetro Angie Peña, counsel for petitioners Edgar Erice and Laila de Lima.
Good morning, Your Honors. I am Attorney Bianca Isabel D. Soriano, also counsel for petitioners in GR number 04036, Congressman Egay Erice and Congresswoman Laila de Lima. Thank you, Your Honors.
Mary, for petitioners in GR 271059, Pimentel et al., may we request the counsel to file the appropriate manifestation for the substitution of the parties with respect to deceased petitioner Edsel Lagman.
Good morning again, Your Honors. May I please proceed? Your Honors, please, we filed a written manifestation, Your Honor, that for the proposed substitution, Your Honor, of the late deceased Congressman Edsel Lagman, Your Honor. And our proposed substitution, Your Honor, is the current Congresswoman of the 1st District of Albay, which is Congresswoman Shelo Crisel B. Lagman, Your Honors, please. She is around in today's proceeding, Your Honors, please.
Thank you. Duly noted.
Thank you, Your Honors.
Appearance for the respondents, please.
Good morning, Your Honors. The Office of the Solicitor General respectfully enters its appearance on behalf of the respondents in these consolidated petitions. I am Solicitor General Darlene Marie B. Berberabe. With me today, Your Honors, are Assistant Solicitor General Marisa B. de la Cruz Galandines, Assistant Solicitor General Maria Victoria V. Sardillo, Assistant Solicitor General George O. Ortha, Assistant Solicitor General Jennifer F. Fanjalan Legaspi, Assistant Solicitor General Samantha P. Kamitan, Assistant Solicitor General Orlando P. Polinar, and Assistant Solicitor General Mark L. Perete. Other lawyers of the OSG are in the gallery to provide assistance whenever necessary, Your Honors.
Appearing as Amici Curiae are Professor Sulita Collas Monsod, Professor Emeritus, University of the Philippines School of Economics, Attorney Florencio B. Abad, Professor of Praxis, Ateneo School of Government, Honorable Franklin M. Dirod, former President of the Senate of the Philippines, and Honorable Benjamin E. Jokno, Member, Monetary Board, Bangko Sentral ng Pilipinas. Thank you very much. As discussed during the preliminary conference conducted last February 4, 2026, and as is stated in the advisory dated February 18, 2026, the parties shall be heard in the following manner. 1. Counsel for petitioners in the consolidated petitions will be heard jointly for 30 minutes. 2. Counsel for the respondents shall be heard immediately after the completion of counsels for petitioners' argument. They shall also have a total of 30 minutes to present their arguments. The time allotted for a counsel to argue shall be exclusive of the time devoted to interpellation by the members of the court. The interpellation of the members of the court will immediately follow after both parties complete the presentation of their arguments. The Council of Petitioners may now approach the podium for their presentation.
The Honorable Chief Justice, Senior Associate Justice, and the Associate Justices of the Supreme Court, good day. I'm Attorney Vopetro Angie Peña. I will be addressing the procedural issue and 4 substantive issues, namely whether unprogrammed appropriations violate Section 22, Article 7, requiring the budget to have sources of financing, whether unprogrammed appropriations are rider provisions, and whether unprogrammed appropriations violate the separation of powers and affect an undue delegation of legislative power. On the sole procedural issue, petitioners respectfully submit that a temporary restraining order must issue enjoining the implementation of Section 43 of RA 12314 or the General Appropriations Act of 2026. Petitioners possess a clear and unmistakable right as citizen taxpayers to ensure that public funds are appropriated and disbursed strictly in accordance with the Constitution. Your Honors, the unprogrammed appropriations create a contingent pool of funds that circumvents the constitutional design of the Constitution and appropriations. It also violates the separation of powers and affects an undue delegation of legislative power. By conditioning release of funds on future events, Congress cedes to the executive the authority to determine when unprogrammed appropriations take effect. This is impermissible post-enactment discretion as prescribed in Belgica versus Ochoa, and it also a clear violation of the separation of powers as affirmed in Arroyo versus Aquino. When fiscal measures erode constitutional boundaries, judicial intervention is imperative. This court in Belgica enjoined the release of PDAF funds to prevent unconstitutional disbursement. This court as well in Pimentel issued a TRO against the transfer of PhilHealth funds and the implementation of constitutional rider in Special Provision 1D under unprogrammed appropriations. In both instances, the court preserved the status quo and prevented the irreversible expenditure of public funds pending judicial review. The same necessity is present here because of the constitutional infirmities in the unprogrammed appropriations. For most, unprogrammed appropriations constitute a rider. The Constitution requires that every provision in the GAA must be germane to a particular appropriation. The President himself recognized that the national budget is 6.793 trillion, corresponding only to programmed appropriations, thereby confirming that the unprogrammed appropriations stand apart from the GAA. Not being related to a particular appropriation, it violates Article 7, Section 22 of the Constitution. As underscored in our earlier, Your Honors, public funds may be disbursed only pursuant to a valid appropriation supported by law. Section 43 identifies no concrete funding source. It relies instead on conditions, excess revenues, new revenues, or loan proceeds. These are not sources of funding, but mere contingencies upon which funding may arise. The President acknowledged in his veto message that releases from the unprogrammed appropriations will still require specification of funding source. This confirms that at the time of enactment, there is no funding base for the revised AFP modernization program, the program for risk management, and the support to foreign-assisted projects. Without a funding base, there is no valid appropriation. Respondents characterize these items as standby appropriation. But, Your Honors, the Constitution has only one mechanism for contingent spending: special appropriations, wherein Congress itself determines at a proper time whether additional expenditures are warranted. The structure of the UA also violates the non-delegation doctrine. Here, the power to determine when unprogrammed appropriations take effect is left entirely to the executive. The executive thus decides not only how to implement the law, but also when it takes effect. The President acknowledged the availability of supplemental appropriations, yet allowed the unprogrammed appropriations to stand. Your Honors, constitutional compliance cannot yield to convenience, practice, or concurrence between political branches. The injury is also actual and imminent. The provision authorizes the release of funds at any time, exposing public funds to immediate unconstitutional disbursement. Once released, they are permanently spent, causing grave and irreparable injury. This honorable court must declare unprogrammed appropriations as unconstitutional to reaffirm that only Congress wields the power of the purse, that appropriations rest on ascertainable funding, and that all public spending must be done within the strict bounds the Constitution commands. Your Honors, if the unprogrammed appropriations are not blank checks, they are checks drawn against insufficient funds, issued not by the people through Congress, but by the executive. These checks must be voided before they are even honored and drawn against the account of the Filipino people. I end my presentation here. I will cede the podium, Your Honors, to my co-counsel. Thank you, Your Honor, for your time and indulgence. May it please
Thank
the
you.
court.
Thank you.
I have a presentation, Your Honor, just a short one.
All in all, average family income of low-income families is about 25 to 30,000 a month. Even at that level, we're discovering that that's not enough to cover food, education expenses, health plan expenses for a family of 5.
Hindi pa tumatas yung sahod. Wala na, binabudget na lang namin. Kunti na lang. Bibili para makaraos lang. Magtipid na lang. Hindi na tayo makain.
Notice, when we use colloquially budget, it means negative. When our supposed representatives use it, it adds. And at whose expense? I asked the court to picture an ordinary Filipino family at their kitchen table. At night, a father places his day's wages on the table, and a mother opens a worn notebook to carefully divide what little they have: rice, tuition, medicine, transportation. Every peso is assigned. Every choice has a consequence. For that family, the budget is a hard limit, not predicted. When money runs out, spending stops. Multiply that limit to the rest of Filipinos, and you have the discipline of a nation. Last time I checked, this nation is a representative democracy. Why then are our representatives doing everything in their power to not represent that discipline? In Republic Act number 11975, the 2024 General Appropriations Act, that discipline was set aside. Instead of a fixed and accountable budget, what was created is a system where spending may expand, shift, and be triggered after the law has already been enacted, without the full safeguards required by the Constitution. At the core of this case are three questions. First, whether program appropriations violate Section 25(4) of Article 6. Second, whether Congress may increase these appropriations beyond what the President proposed. And third, whether Congress may enact new programs, activities, and projects. These questions may appear technical, but they all point to a single principle. The Constitution requires discipline, clarity, accountability in the use of public funds. On the first issue, Section 25(4) of the Constitution requires that any special appropriations bill state the purpose and be supported by funds actually available as certified by the National Treasurer, or be matched with a corresponding revenue proposal. These are not mere technicalities. They are safeguards designed to prevent abuse and to ensure that the government cannot simply move money around at will. However, program appropriations do not comply with these requirements. They become usable only later when certain conditions are met, are not funded at the time the law is passed, and in relation to Section 25(5), do not depend on savings. In the 2024 GAA, these conditions were even expanded to include, among others, the use of government-owned or controlled corporations' fund balances. This means that spending authority can arise after the budget has already been approved. That is not transfer of funds within constitutional limits. It is in substance the creation of a new appropriation after the enactment. When spending authority exists without savings, without definite appropriation at the outset, and without safeguards required by the Constitution, Section 25(4) is not being followed. It is being bypassed. On the second issue, the Constitution is equally clear. Congress may not increase the appropriations recommended by the President. This rule ensures fiscal discipline by requiring that the national budget be anchored on the executive's projections of revenues and expenditures. The President's proposal reflects a coherent fiscal plan based on actual economic realities. Yet in this case, Congress expanded on program appropriations far beyond what was recommended. What was originally limited to 8 purposes was enacted to 51 purposes, transforming a narrow standby mechanism into a broad and flexible source of spending authority. Even if the total figures may appear similar at first glance, the Constitution is not concerned only with arithmetic totals, but with the power those figures represent. By expanding the purposes, the triggers, and the flexibility of these appropriations, Congress effectively increased the government's authority to spend. This is a functional increase, one that achieves indirectly what the Constitution expressly prohibits directly. If this is allowed, the prohibition in Section 25(1) becomes meaningless, as Congress could always bypass it simply by labeling appropriations as conditional rather than actual. On the third issue, the reclassification of programs, activities, and projects between program and unprogrammed appropriations further undermines constitutional safeguards. A programmed appropriation is funded, definite, and ready for implementation, while an unprogrammed appropriation is contingent and uncertain. Allowing movement between these categories changes the natures of the appropriation itself. A project that was certain becomes uncertain, and one that was conditional may later be treated as funded, all without passing a new law. This is not merely an administrative adjustment. It is, in effect, a rewriting of the budget after it has already been approved. Such mechanism defeats the requirement of specificity, weakens accountability by deferring decisions to post-enactment processes, and blurs the separation of powers by shifting fiscal decision-making away from Congress at the time of legislation. Ultimately, what emerges from these mechanisms is a system that the Constitution does not recognize. A shadow budget that is contingent, expandable, and dependent on discretion after enactment. Public funds belong to the people, and their use must be governed by clear constitutional limits, not by shifting conditions or post-enactment authority. If an ordinary Filipino family must live within its limits, then our representatives must live within the Constitution. Thank you, Your Honors.
Thank you.
May it please the court. I'm Attorney Joseph Lemel Bakiran, Your Honor, respectfully appearing as counsel for petitioner FPJPM. For the petitioner's FPJPM, Your Honor, we are assigned two topics. That is, whether the legislative branch may validly increase the amount of special accounts in the general fund recommended by the executive branch. And the second one is whether the legislative branch validly increase the earmarked funds for the Road Users Fund by reallocating items in the 2025 General Appropriations Act. Your Honors, This petition raises constitutional question of the highest importance. Whether Congress, through the Bicameral Conference Committee, may increase appropriations beyond those recommended by the President in violation of Article 6, Section 25, Paragraph 1 of the Constitution. At stake, Your Honors, is not merely a difference in figures. What is at stake is the constitutional boundary between the executive initiative and legislative authority and the integrity of the national budget process itself. Your Honors, the facts are undisputed. The President submitted the 2025 National Expenditure Program with a total expenditure level of 6.352 trillion, including 27.352 billion in special accounts in the general fund. These special accounts in the general fund form part of automatic appropriations, funds governed by law, sourced from earmarked revenues, and intended to operate with limited legislative discretion. Among these is the Special Road Fund, sourced from motor vehicles users charged under Republic Act 8794, as amended, strictly tied to actual collections and specific statutory issues. However, Your Honors, during the bicameral deliberations, Congress introduced substantial increases. The special accounts in the general fund was increased from 27.352 billion to 40.107 billion. The special road fund was increased from 16.756 billion to a staggering 34.748 billion, or an amount of 17.992 billion, Your Honors. These are not minor adjustments. These are structural expansion of the budget. This brings us to the first issue, whether Congress may increase appropriations beyond the President's proposal. The Constitution is unequivocal. Article 6, Section 25(1) expressly prohibits Congress from increasing the appropriations recommended by the President. Congress may reduce, may realign, or modify, but it may not increase. Yet here, Your Honors, the Bicameral Conference Committee did precisely what the Constitution forbids. By increasing the special accounts in the general fund, an automatic appropriation, Congress expanded the total expenditure program beyond the President's proposed ceiling. This is not amendment. This is unconstitutional expansion. The violation becomes more pronounced when the nature of these funds is considered. Special accounts in the general fund are not ordinary appropriations. They are funded by earmarked revenues. They are governed by specific statutes. And they are automatically appropriated based on available income. In short, they are revenue-bound and self-executing. Yet Congress increased these funds without any corresponding increase in earmarked revenues. This breaks a fundamental rule that special funds may only be spent to the extent of what is actually collected or authorized by law. This leads to the second issue, whether Congress gravely abused its discretion in increasing the special road fund beyond its lawful limits. The special road fund is clear in both law and structure. It is funded exclusively by the motor vehicles users charge and may only be programmed within actual or projected collections. But here, Your Honors, the additional 17.992 billion did not come from the motor vehicle users' collections. It came from pooled funds and general budgetary sources. Your Honors, this is constitutionally untenable. Because once a fund is detached from its earmarked source, it ceases to be a special fund. It becomes an unauthorized appropriation, merely labeled as one. Taken together, these acts reveal a clear pattern of unconstitutional overreach. First, by increasing appropriations beyond the President's proposal, and second, by detaching special funds from the statutory revenue sources. Both acts produce the same result, an unauthorized expansion of the national budget. Your Honors, this case is not about policy. It is not about whether these expenditures are beneficial. It is about whether constitutional limits still bind the political branches. In this action, if these actions are allowed to stand, Your Honors, then the prohibition in Article 6, Section 25(1) becomes illusory. The bicameral conference committee would effectively acquire the power not merely to reconcile, but rewrite the national budget. And the constitutional balance between the executive and legislative branches would be fundamentally altered. In closing, Your Honors, the Constitution entrusts this most honorable court with the duty to enforce the limits of power, especially in matters of public spending. Because when those limits are ignored, what is placed at risk is not only fiscal discipline, but the rule of law itself. For these reasons, petitioners respectfully pray that the said provisions of the 2025 General Appropriations Act be declared unconstitutional and that the acts of the Bicameral Conference Committee be struck down for grave abuse of discretion. Thank you, Your Honors.
Thank you.
The Honorable Justices of the Supreme Court, good morning, Your Honors. I am Attorney Elmar Barreda, and this representation, Your Honors, please, will argue on the following substantive issues, Your Honor, please. Number one, whether the legislative branch may validly increase any appropriation recommended by the executive branch. Number two, whether the legislative branch may validly move programs, activities, or projects, PAPs, from the program appropriations to unprogrammed appropriations and vice versa. Third, whether the Congress may make new PAPs not found in the National Expenditure Program. Your Honors, please, let me proceed. It is argued that the legislative branch may validly increase any appropriation recommended by the executive branch, may not validly increase any appropriation recommended by the executive branch. To support these arguments, Your Honor, the law prohibiting the legislative branch from increasing any appropriation recommended by the executive branch is Section 25, subsection 1 of Article 6 of the 1987 Constitution, unequivocally stating that the Congress may not increase the appropriations recommended by the President for the operation of the government as specified in the budget. The form, content, and manner of preparation of the budget shall be prescribed by law. Section 25, subsection 1 of Article 6 of the 1987 Constitution is a limitation imposed upon the Congress not to increase the appropriations recommended by the President for the operation of the government as specified in the budget. The text of the petition in GR number 271059, as formulated by the petitioners Edsel Silagman and Mujib S. Hataman, is that this limitation is absolute, where the Congress is without any discretion to increase the President's recommendation in the National Expenditures Program, or the NEP. The phrase as specified in the budget in Section 25, subsection 1 of Article 6 of the 1987 Constitution defines the subject appropriations that the legislative branch may not increase. In other words, the ban on the increase applies to any kind of appropriation so long as it is specified in the budget. This point is important because the subject constitutional provision made no mention the collective words program appropriations and unprogrammed appropriations. To denote two different kinds of appropriations, one between the two, which is the unprogrammed appropriations, is the subject of the petition in GR number 271059, insofar as the excess amount from the President recommended budget in the NEP. Specifically, in GR number 271059, seeks to vanquish in the 2024 General Appropriations Act, or RA 11975, the amount of 449.5 billion, representing the excess from the amount of 289.1 billion in unprogrammed appropriations the President recommended. Notably, the excess amount of 449.5 billion in the unprogrammed appropriations is not supported by the recommendation of the President, is greater than the amount of 289.1 billion supported by the recommendation of the President. Section 25, subsection 1 of Article 6 of the 1987 Constitution should be read in conjunction with Section 22, Article 7 of the 1987 Constitution, stating that the President shall submit to the Congress within 30 days from the opening of every regular session as the basis of the General Appropriations Bill, a budget of expenditures and sources of financing, including receipts from all existing and proposed revenue measures. Clear in the Constitution, Your Honors, please, that the General Appropriations Bill must be based on the budget of expenditures submitted by the President to the Congress. In other words, the President's National Expenditures Program is the legal foundation of the Congress General Appropriations Bill. Thus, appropriations beyond or outside what the President recommended is without basis as required under Section 22, Article 7 of the 1987 Constitution. Clearly, in GR number 271059, the excess amount of 449.5 billion in the unprogrammed appropriations is without constitutional basis, not being covered by the President's recommendations, capped only at 289.1 billion. Thus, as prayed for by the petitioners Edsel C. Lagman and Mujib S. Hataman in their petition, the challenge excess of 449.5 billion should be nullified in the 2024 General Appropriations Act. Without noting any bad faith on the part of the executive branch in the preparation of the annual budget for 2024, the heads of agencies and departments of the national government and the President enjoy the presumption of regularity in the performance of official duties. Thus, budget documents they formulated should not have been disturbed by the Congress by increasing the unprogrammed appropriations in the 2024 General Appropriations Act, or RA 11975. Moving forward to the next assigned issue, Your Honors, please. It is argued that the legislative branch may not validly move programs, activities, or projects from program appropriations to unprogrammed appropriations, and vice versa. Notably, when this Honorable Supreme Court promulgated on December 3, 2025, its decision in consolidated GR numbers 274778, 275405, and 276233 in their separate concurring or dissenting opinions, three honorable justices opined about this legal issue as follows. First, the Honorable Senior Associate Justice Marvic Leonen stated that the national budget originates from the executive department. Each department or agency can already determine what the potential expenses are for the coming years, including miscellaneous expenses. Thus, it is already anticipated. It is not right to transfer them to unprogrammed appropriations. Second, Your Honors, please. Honorable Associate Justice Alfredo Benjamin S. Caguioa stated that in sum, I respectfully submit that moving PAPs from the program to unprogrammed appropriations violate the principle of separation of powers based on the following grounds. First, Congress encroached on the budget preparation phase by arrogating unto itself the function of prioritization of programs for the implementation of the executive, vis-a-vis the allocation of available funds. Second, the Congress exceeded its power to appropriate when it increased the total appropriations by inserting new PAPs. Third, Honorable Associate Justice Ramon Paul Hernando stated that unprogrammed appropriations in any form are unconstitutional. It is submitted that the opinions mentioned are the most recent and relevant to support the argument that the legislative branch may not validly move programs, activities, or projects from the program appropriations to unprogrammed appropriations and vice versa. There is no cogent reason that this opinion should not be adopted as well as by this Honorable Supreme Court in the resolution of the legal questions involved in the present petition. Going to the last assigned issue, Your Honor, it is argued that the Congress may not make new PAPs not found in the National Expenditure Program. If the Congress may not increase any appropriations recommended by the executive branch, as the same will have no basis pursuant to Section 25, subsection paragraph 1 of Article 6, in conjunction with Section 22, Article 7 of the 1987 Constitution, as earlier argued. Logically, the Congress may also not make new programs, activities, or projects not found in the National Expenditure Programs, because the same will also no legal basis under the same constitutional provision. Likewise, as opined by the Honorable Associate Justice Alfredo Benjamin S. Caguioa, Congress exceeded its power to appropriate when it increased the total appropriations by inserting new PAPs. In doing so, the Congress committed grave abuse of discretion amounting to lack or amounting to lack or excess of jurisdiction, justifying once again the need for this Honorable Supreme Court to exercise its expanded power of judicial review. The worst instance of grave abuse of discretion is a blatant violation of the 1987 Constitution, Your Honors. In closing, Your Honors, please, it is most respectfully implored of this Honorable Supreme Court to grant the petition of Edsel C. Lagman and Mujib S. Hataman to nullify by declaring unconstitutional the excess of 449.5 billion in unprogrammed appropriations in the 2024 General Appropriations Act, or RA 11975, in GR number 271059. Thank you very much, Your Honors, please.
Thank you. The Solicitor General may proceed to the podium for her presentation. Please proceed, sorry. Sino siya?
May it please the Honorable Court, once again, Your Honors, good day. I am Bianca Isabel D. Soriano, appearing for petitioners Teresa and Laguna. On issue number 2E, whether the legislative branch may validly create new programs, activities, or projects or PAPs not found in the National Expenditure Program or the NEP, petitioners for GR number 04036 is of the affirmative position, but within its defined constitutional limits. Your Honors, this case is not about expanding nor diminishing the Congress's power of the purse. It is about preserving that power within its constitutional design. As early as the 1994 case of Phil Consa versus Enriquez, this honorable court held that while the President may propose the budget, the final say on appropriations in the matter is lodged in Congress. Thus, the legislative branch is not confined in the NEP. It may amend, adjust, and even introduce new PAPs. But to clarify, Your Honors, that authority is not unbounded. First, under Section 25.1, Article 6 of the Constitution, Congress may not increase the total appropriations beyond the amount proposed by the President. The President proposal thus operates as a fiscal ceiling, ensuring discipline in public spending. Second, jurisprudence teaches that appropriations must be specific, definite, and for a particular public purpose. Safeguards that ensure accountability in the use of public funds. These are not mere formalities, they are constitutional safeguards that define the limits of legislative power. In sum, Your Honors, for petitioners in GR number 04036, the legislative branch may create new PAPs not found in the NEP, as long as it respects the constitutional ceiling and adheres to the safeguards to discipline the use of public funds. Anything less would diminish Congress's role. Anything more would distort the Constitution. Thank you, Your Honors, and may it please the Honorable Court.
Thank you. The Solicitor General, please proceed with your presentation.
Chief Justice Mundo, Senior Associate Justice Leonen, Associate Justices of the Supreme Court and Bank. I am Solicitor General Darlene Marie B. Berberabe, and with me are the Assistant Solicitors General and Solicitors. Ano ang akma at makatarungang budget? Kung tatanungin ang magsasaka, manggagawa, guro, ang isang ina, marahil ito ang sagot. Isang budget na tumutugon sa kanilang mga pangangailangan, pagkain sa hapag, edukasyon para sa mga anak, maayos na kalsada, ospital na mapapagdalhan ng may sakit, at trabaho para matustusan ang pangangailangan ng pamilya. Ang bawat isang nagbabayad ng buwis ay umaasa na ito ay ilalaan para sa kanila ng tama, maayos at buong katapatan. That is the national budget that each government works towards. And the 1987 Constitution provides the framework to make that happen. It assigns to the executive and the legislature a specific, defined role in the budget process. The Constitution recognizes that a responsive budget requires both the executive's knowledge of government capacity and resources and the legislature's understanding of what the people actually need. This is the meaning of separation of powers, that government authority is divided among three branches: legislative, executive, and judicial, so that no single branch becomes too powerful. Each branch has its own role, and the Constitution itself prescribes the mechanisms to ensure the balance of power as well as accountability. The executive handles administration, the legislature enacts, the judiciary interprets the law, each branch in its lane, each branch doing its constitutional duty. Some issues are intended to be left to the political branches of the government. In our jurisdiction, the determination of whether an issue involves a truly political and non-justiciable question lies in the answer to the question whether there are constitutionally imposed limits on the powers or functions conferred upon political bodies. If there are, and a petition is lodged before the court, then our courts are duty-bound to examine whether the branch or instrumentality of the government properly acted within such limits. This is what we hope to thresh out today, whether in passing the General Appropriations Act of 2024, 2025, and 2026, the executive and legislative exercise their power within the limits imposed by the Constitution. The Constitution assigns to the executive the task of planning the budget. Under Article 7, Section 22, the President must submit to Congress a budget of expenditures and sources of financing. This is a plan prepared by the executive, a plan grounded in what the government can realistically accomplish and what the country can afford. The President, through the DBM and the economic managers of government, is best positioned to know the condition of public finances, the capacity of implementing agencies, and more importantly, the realistic projections for revenue. The President's proposed budget is based on that knowledge. The Constitution assigns Congress the task of deliberating on behalf of the people. Senators and representatives are elected to represent their constituents' needs. They are in the best position to know what roads are required and where they must be built, what hospitals are lacking, which communities need classrooms. Congress holds hearings, questions cabinet secretaries, studies and debates priorities before it enacts the budget. Congress is constitutionally given the power of the purse. The Constitution assigns this honorable court the task of determining, when properly petitioned, whether Congress and the executive have exercised the power that the Constitution has assigned to each. In exercising this power, the court does not pass upon the wisdom, necessity, or policy choices made by the legislature in enacting the GAA. These are matters within the exclusive domain of Congress. Rather, the court's review is narrowly confined to questions of constitutionality, of whether the constitutional limits have been breached. It may examine whether the GAA complies with constitutional requirements, such as single correspondence rule, the prohibition against riders, the requirement that appropriations be for public purpose. It may also strike down provisions that unduly delegate legislative power or infringe upon the powers of other branches. It is only upon a clear showing of violation of constitutional rules or of grave abuse of discretion by its co-equal branches that the court's power of review is triggered. This is important to preserve institutional independence and mutual respect. In Arroyo versus De Venecia, this court, with its wisdom and disciplined regard for constitutional boundaries, said that in passing upon the validity of legislative acts, the court acts with caution and restraint, for there is always the danger that in the exercise of judicial power, it may be taken as engaging in the usurpation of the power of legislation. The legislative process, including the passage of the GAA, carries the presumption of constitutionality. The enrolled and authenticated bill signed by the presiding officers of both houses is evidence of its due enactment. According to Arroyo, in the absence of evidence to the contrary, the court will respect the certification of the presiding officers of both houses that a bill has been duly passed. Kagalang-galang na mga mahistrado, pahintulutan po ninyong mailahad ko ang kaibuturan ng usapin ngayon. Ano ba itong unprogrammed appropriations? Ito ba ay lumalabag sa konstitusyon? May nilabag ba sa konstitusyon ang dalawang sangay ng gobyerno nang ipinasa ang GAA ng 2024, 2025, 2026? Ipinagbabawal ba ng saligang batas ang paghahanda ng listahan ng mga programa na ang pagkukunan ng pondo ay kakaiba sa pondong pagkukunan ng mga programang may prioridad? In their simple form, these are the questions raised against the constitutionality of unprogrammed appropriations. Before addressing the constitutional questions directly, allow me to explain what unprogrammed appropriations actually are. Petitioners' characterizations of them as blank checks and shadow budgets are politically agitating, however, they are incorrect. Let me use an analogy. Kapag nagpaplano ang isang pamilya ng kanilang budget, sila ay nagkikwenta kung magkano ang pondo ng pamilya, magkano ang kinikita ni nanay, ni tatay, at lahat ng pagkukunan ng pera ng buong mag-anak. Pagkatapos, maglilista, ano-ano ba ang pagkakagastahan? Bahay, pagkain, pamasahe. Pagkatapos nito ay ililista rin magkano ang bawat isang pagkakagastusan. So may dalawang kategorya sa budget ng pamilya. Una, ang mga pangunahing pangangailangan ay dapat mapaglaanan ng pera. Ang pagkain, upa sa bahay, tuition fee, kuryente, pamasahe. Pipiliin ng magulang kung alin ang kinakailangan para mairaos ang disenteng pamumuhay araw-araw. Subalit, maganda rin sana na may mailaan para sa pagpapagawa ng bubong, makabili ng laptop, makapasyal sa park, makabili ng motorsiklo. Ito ang pangalawang kategorya. Ito ay mga kailangan din para mas umangat ang kalidad ng buhay. Magandang maisama na rin sa plano dahil pwede naman magtinda ng lutong bahay pandagdag kita o kaya naman may bonus na matatanggap sa trabaho si nanay o magkaumento sa sahod si tatay. Kahalintulad nito ang programmed at unprogrammed appropriations. Ang programmed ay ang prioridad na pagkakagastusan. May kabangga itong pagkukunan ng pera na mas tiyak at nakaplano ng darating. Samantalang, ang unprogrammed ay yung mahalaga ring mapaglaanan ng pera dahil sa ikabubuti rin naman ito ng pamilya, pero ang pagkukunan ng pera ay hindi pa tiyak, pero may basihan. In every Filipino household and in every budget, there are needs that must be met no matter what. There are also aspirational needs which, while important to improve the quality of life, can only be met if and when money becomes available. The government, like every Filipino family, plans for both. Your Honors, unprogrammed appropriations are the government's aspirational priorities, programs which are also needed and ready for implementation, but whose funding depends on specific fiscal events that may or may not occur. Their funding sources, as determined by Congress, consist of first, non-tax revenue collections that exceed government targets. Second, new revenue collections from new tax or non-tax sources. Or third, proceeds from approved loans for foreign-assisted projects. The purposes for which unprogrammed appropriations are passed are not secret. They are legislated and publicly available. If none of the triggering events happens, not a single centavo may be released. Before any peso can move, a fiscal condition must be met. The Bureau of Treasury must certify it. The DBM must issue an allotment, and the implementing agency must submit a special budget request. Only then may DBM issue a special allotment release order. These are specific steps that the executive branch takes in order to comply with the clear targets set by the legislature. The unprogrammed appropriations are neither a blank check nor unconditional. They are among the most conditioned and controlled spending authorizations in the entire government system. Unprogrammed appropriations give the government fiscal flexibility. They ensure that a windfall does not go undeployed while public needs go unmet, without requiring anew a full deliberative cycle of a special appropriations bill which duplicates effort and takes time to pass. Since the 1987 Constitution, across administrations, from President Cory Aquino in 1989 to Presidents Ramos, Estrada, Arroyo, Aquino, Duterte, and now President Marcos, unprogrammed appropriations have been a standard and relied upon feature of the national budget year after year. This long history manifests consistent, contemporaneous constitutional construction by the court's co-equal branches, which should not be taken lightly. As this court aptly stated in KMU versus Aquino, a parameter of judicial review is determining who can read the Constitution. Interpreting its text has never been within the exclusive power or province of the courts. Other branches of government are equally able to provide their own interpretation of the provisions of our organic law, especially on the powers conferred by the Constitution and those delegated by Congress. More importantly, the constitutionality of unprogrammed appropriations has already been ruled upon by the Honorable Court. In Araulio versus Aquino in 2014, the court recognized unprogrammed funds as a legitimate source of government financing, subject to their specific trigger conditions, and applied those conditions in assessing the legality of disbursements under the Disbursement Acceleration Program. And in Belgica versus Executive Secretary in 2019, the court ruled explicitly and categorically the appropriation for the unprogrammed fund is constitutional. It has a clearly discernible singular appropriation purpose. It complies with the rule on singular correspondence. It is not a prohibited lump sum fund. It does not constitute an unconstitutional post-enactment legislative intrusion. The petitioners asked this court to overrule Belgica 2019, but they have not presented a single compelling reason, whether factual or doctrinal, in support of their challenge. Without having discharged their burden, petitioners' constitutional challenge should not be allowed to stand. Mr. Chief Justice, honorable members of the court, allow me at this point to directly address some constitutional questions as identified by the court's advisory. First, do unprogrammed appropriations violate Section 22, Article 7 of the Constitution? The answer is no. Article 7, Section 22 requires the President to submit a budget of expenditures and sources of financing, including receipts from existing and proposed revenue measures. The President did precisely that. The Erice petition argues that the sources must be actually existing at the time of the submission of the proposed budget by the President and when the GAA is enacted. But Section 22 does not require this. What it requires is for the budget to be based on existing and proposed revenue measures, meaning the revenue sources must be identifiable and real, not speculative. A budget based on revenue programs is fully consistent with Section 22's mandate. Second, do unprogrammed appropriations violate Section 25 for Article 6? The answer is no. By its express terms, Section 25, Number 4, Article 6 of the 1987 Constitution merely applies to special appropriations bill, not to general appropriations bills. It requires that a special appropriations bill be accompanied either by 1, a certification of availability of funds issued by the National Treasurer, or 2, a corresponding revenue proposal where funding is not yet available. Unprogrammed appropriations, however, form part of the GAB. Accordingly, Section 25, Number 4, Article 6 of the 1987 Constitution does not govern their inclusion in the GAA. Third, are unprogrammed appropriations rider provisions that violate Section 25, Number 2, Article 6? Again, the answer is no. Unprogrammed appropriations are not foreign to the GAA's purpose. BELHICA 2019 already held that they have a clearly discernible singular appropriation purpose. A provision that has a discernible appropriation purpose cannot simultaneously be a rider lacking germane purpose. In Atitiu versus Zamora, the court, recognizing that an appropriations bill covers a broader range of subject matter and includes more details compared to an ordinary bill, stated that its provision is germane if particular, unambiguous, and appropriate, given their specified purposes, defined amounts, and explicit conditions. Unprogrammed appropriations meet this standard. Fourth is the rule which prevents Congress from exceeding the budget ceiling proposed by the President violated when unprogrammed appropriations are enacted or when Congress increases their specific sums. Again, no. As Commissioner Davide explained in the Constitutional Commission deliberations, the purpose of the prohibition imposed by Section 25, Number 1, Article 6 is fiscal discipline. It prevents Congress from authorizing programmed expenditures that would exceed projected revenues and produce a budget deficit. Unprogrammed appropriations cannot produce that effect because the sources of funds are different from the sources of funds of the programmed appropriations. Fifth, do unprogrammed appropriations violate the constitutionally guaranteed separation of powers? Again, the answer is no. The legislature is given the power of the purse, and in exercising it, the Constitution and jurisprudence require that there is a line item appropriation that corresponds to a single purpose. Did Congress do this? Yes. In the GAA, Congress has identified each specific purpose for which unprogrammed funds may be used, fixed the maximum amount per purpose, specified the 3 exclusive trigger conditions for release, and required administrative certifications and approvals before any peso moves. Did the executive usurp the legislative function of deciding the purpose of some appropriation? The answer is no. What the executive does is not legislative policy making, but administrative implementation. It verifies that a trigger has occurred before releasing funds to a pre-approved purpose in a pre-approved amount. The separation of powers is not violated. The decisions on purpose and amount are made by Congress, and the administrative execution is performed by the executive. The lines that demarcate the constitutional functions are unmistakably clear. Your Honors, this case is not a forum to debate the wisdom of policy choices or the merits of particular appropriations. These are matters entrusted to the political branches and to other mechanisms of accountability, which are also constitutionally provided. The question is whether the existence of unprogrammed appropriations per se violates the Constitution. What is asked of the Court today is the exercise of its own constitutional function to determine whether the limits set by the Constitution have been observed by the Executive and Congress. The inquiry is thus a narrow but fundamental one, whether there has been a breach of constitutional restrictions. This case does not call for an inquiry nor a judgment upon the processes by which Congress determines the contents of appropriations or by which the executive identifies what should be included in the people's budget. We elect our representatives upon whom the people have lodged through the Constitution the power of the purse. we elect the President in whom the people, through the Constitution, entrusts the administration of the budget. Are there governance challenges? Are there better uses of funds? Could certain appropriations be lesser and others more? Does the existence of unprogrammed appropriations make the budget vulnerable to abuse? These questions are not for this honorable court to answer nor to solve. The Constitution entrusts power to the political branches with the expectation of responsibility, not infallibility. Where the mechanism is not prohibited, the answer to potential abuse is not its elimination, but the continued vigilance of the people, whose judgment, expressed through public opinion and ultimately the ballot, remains the highest check in a constitutional democracy. Aside from the power of the ballot, the power of legislative oversight, the power of the Commission on Audit, the power of the Ombudsman, the freedom of speech behind civil society scrutiny are crucial tools under our Constitution to hold the political branches accountable for how they exercise the budget power. The Honorable Court, with its wisdom and authority, can discern the lines drawn by the Constitution with precision, hold each branch to it, and do so with judicious restraint. Your Honors, the Constitution assigned the President the power and duty to propose a budget grounded in fiscal reality. The President did that and followed what was constitutionally required. The Constitution assigned Congress the power and duty to deliberate on that budget on behalf of the people. Congress followed what was constitutionally required. Respect for the separation of powers demands the utmost wisdom of this honorable court. The invalidation of an entire legislative mechanism should not be done unless the petitioners have shown a clear and irreconcilable conflict with the Constitution. It is our position that they have not. Tungkulin ng kapitapitagan at kataas-taasang hukuman ito na bantayan ang mga linyang itinakda ng konstitusyon. Sa ganang amin, sa paghahandang tugunan ang mga pangangailangan ng sambayanan gamit ang unprogrammed appropriations, isinaalang-alang ng ehekutibo at lehislatura ang mga linyang ito, sapagkat ang pagmamay-ari ng kaban ng bayan ay nasa sambayanan. Maraming salamat at magandang umaga po.
Thank you, Solicitor General. May we call Professor Solita Collias Monsod as amicus to make her presentation.
Stay here.
If your honors please, I have a PowerPoint presentation, but while they're putting it up, I'd like to say that I'm so very glad I'm not a lawyer, because you have lawyers on both sides and you'd think both are right. I am here to, as instructed, to give you a broader view, a non-legal view, an economic view of what is going on in the country today with respect to unprogrammed appropriations. Is it up already? Not yet. Okay. Okay. Sandali lang, ito pa. No, what is happening? Yes, but I'm yes, yes. The presentation is called ABCD, about the budget, corruption, and development. At the heart of this matter, as far as I am concerned, Your Honors, is the abuse of legislative and executive power for private gain, in other words, corruption, occurring during the budgetary process. Such abuse amounts to a large opportunity costs that cannot but impinge on our ability to obtain the development objectives of the country as expressed in the Philippine Development Plan 2328. What power is being abused? Well, it's the power of the purse. This abuse has been perpetrated in the form of the pork barrel. For the executive, it is the power to choose which programs, projects, activities are to be funded first. It is also the power to release or withhold funds. One of the major dimensions of public budgeting has been planning for economic development through economic growth. A development plan provides a vision, but the budget provides the operational framework. And it goes without saying, but I'll say it anyway, that if the budget fails, the plan fails. And the country pays for it. Then we have the Philippine Development Plan 23-2028, and there are objectives, etc., with results matrices all over the place, about 500 indicators, but there are 11 major indicators. And 3 of those are directly connected with the budget. This is the annual rates of growth of GDP, the national government deficit to GDP, and the outstanding NG debt to GDP. As we all know, the National Expenditure Program is based on a set of macroeconomic assumptions on GDP growth rate, inflation, interest rates, exchange rates, etc., which are in turn based on projections, forecasts of the Development Budget Coordinating Committee, the economic managers. And the NEP is anchored on the Philippine Development Plan. Well, what happened? Well, on November 13, 2013, this honorable court dealt a mortal blow to the pork barrel. We thought it was dead. Policymakers then were faced with 2 choices. They could, 1, institutionalize necessary reforms to public financial management system so that pork could no longer be a problem. In other words, they would pass a proposed Public Financial Accountability Act, ensure projects were owned by the people through bottoms-up budgeting. Or they could devise a new form of pork. That was the low road. They took the low road. Okay. From that November 13 decision, let me update the court. From 2014 to 2016, the President Pinoy Aquino obeyed the Supreme Court. In fact, he abolished the PDAF even before the Supreme Court made its decision. They brought in bottoms-up budgeting, they brought in the Comptroller General and proposed the Public Financial Management Bill, which was introduced but has never been passed. And then from 2016 to 2022, President Duterte also ran on an anti-corruption platform, but the pork barrel came back with a vengeance. Because 2017, Speaker Pantaleon Alvarez said there was no pork barrel because everything was itemized. So if everything is itemized, it does not become a pork barrel. There was a standoff in 2019. The budget had to be what do you call that? Reenacted because the president took off $95 billion, 95 billion pesos from the budget. He did it, but in 2020, the Congress recalled the 2020 budget because they wanted to put the 95 billion pesos back in. And that is the time when the contractors became part of the scene. From 2022, a more sophisticated system has come into place where the pork barrel has become a part of the budget preparation embedded in the National Expenditure Program, where there would be no need to make insertions. The so-called baseline balanced management formula, or BBM, was adopted by the DPWH. The entire DPWH infrastructure budget became a pork barrel. The pork barrel system versus the new pork barrel system versus the PDAF. Well, the new pork barrel system obviously is obscenely larger in scale. The PDAF was about 24 billion pesos. And now, since 2023 anyway, the pork barrel is the entire infrastructure project of the budget of the DPWH, divided into allocables and non-allocables. Choice of the projects are made mostly while NEP is being prepared. Note, as testified by the late Undersecretary Cabral, that projects amounted to 50% of the DPWH NEP. Then a legislature may propose projects outside of his district, so long as he pays a parking fee or standard operating procedure of 6% to the district representative. This is and finally, here comes the unprogrammed appropriations. The unprogrammed appropriations was chosen as the place to hide the lump sum appropriations. There was the SAGIP and the BIP. The SAGIP is the Strengthening Assistance for Government Infrastructure and Social Programs, and there was something called the BIP. In other words, the unprogrammed appropriations became the repository of these BICAM assertions. And this is where we talk about obscenely large. This is where this graph shows unprogrammed funds appropriations approved, and the approved unprogrammed funds have exceeded proposed unprogrammed funds. Notice in this graph, if your honors please, you will notice that the dark blue line shows where the unprogrammed and the NEP and the GAA were the same as far as unprogrammed and appropriations are concerned. But in 2022, they started growing. And if you'll see that high point there, that's where unprogrammed appropriations started. Wow. They went up to 800 billion pesos, which is more than the budget department appropriations. And notice that the dark blue and the light blue bars is where the general appropriations exceeded the National Expenditure Program. Anyway, you could see the ballooning of the unprogrammed appropriations. Now, so these unprogrammed appropriations need financing. Serendipitously, it was also starting in 2021 when the budget for expenditures and sources of financing showed unprecedented. It never happened before. But the budget of expenditures and sources of financing showed these excesses of actual revenues over projected revenues. It had never happened before, but it started happening in 2021, 22, 23, and 24, if you will look at those graphs. So, and of course, serendipitously, it happened in the 2024 unprogrammed appropriations there was an additional provision that said that apart from excess and new revenues, loans for foreign assisted projects, the fund balances of the government-owned or controlled corporations from any remainder resulting from the review and reduction of the reserve funds. Anyway, this provision was put in 24, and it was taken out for the 24-25 budget because I think the Supreme Court did something. Whatever you did something good. Okay. All right. So, what are the direct consequences? We're talking about to the economy and to the fiscal picture. The direct consequences of the unprogrammed appropriations, first, they dilute congressional control over public spending in the following ways. And this comes from the study made by the Congressional Programming and Budgeting Policy Research Department, the think tank of Congress. So it says it weakens budget transparency through legislative scrutiny. It increases, in other words, the legislature cannot scrutinize because this SAGIP, which amounted about 300 billion in 2024, is essentially a lump sum. It increases the risk to discretionary allocation. Why? Because the president, the executive, decides which one goes out first and which ones should be held up for later release or something. It blurs this institutional accountability. It undermines fiscal discipline and debt sustainability. It weakens the link to development planning. When items are removed from the programmed appropriations to the unprogrammed appropriations and vice versa, it completely removes the prioritization of the fiscal in the fiscal scene. This is what the CPBRD said. UA, unprogrammed appropriations, originally conceived as a limited standby mechanism to provide fiscal flexibility in the face of uncertainty. However, the rapid expansion in recent years, coupled with weak itemization, conditional funding triggers, post-enactment executive discretion, has transformed them into a budgetary instrument with significant implications for transparency, accountability, and fiscal discipline. Now, the way I read it, that means, it's terrible for good governance. Higher than planned spending, especially when funded through borrowings, could lead to larger annual budget deficits. This resulted partly in the failure of the government to meet its targets for reducing the budget deficit and the deficit to GDP ratio. Let me show you exactly what the effect of these unprogrammed appropriations have been to our budget deficits. Some of our targets. What is the status? For example, in the growth of GDP, that is number one in economic growth target. The actual growth targets versus the growth targets versus the actual. Your orange lines are the actual, and the blue lines are the target. That first graph shows that the growth targets have not been met. In fact, they're going down instead of going up for the years 23, 24, and 25. And then the NG, deficit to GDP ratio. The NG, notice that the actual deficits are much larger than what was programmed, what was put down by the DBCC. In spite of the fact that DBCC started retargeting, those broken lines are the retargeted targets. Notice that still the budget deficits have grown so much between 2023 and 2025. That has to do with the pork barrel. Well, unprogrammed appropriations is only one way of having a pork barrel. There's the pork barrel that is in the NEP, and then, of course, the BICAM and the unprogrammed appropriations. And finally, the outstanding debt stock to GDP ratio. Again, the targets were always to reduce that GDP debt stock to debt stock to GDP ratio. Notice that the orange line is going up. The blue lines are the target, and the broken lines are the retargeted. So, in other words, this is what has happened to some of our targets in the PDP, and these are directly attributable to the pork barrel. Now, what about the status of our income, health, learning development targets? It's too early to tell, but our children and the poor cannot continue to bear the waste and the opportunity costs. As it is, Your Honors, we are an underperformer. 2 weeks ago, that was what we were called. We were underperformer among the ASEAN 5. Here are some major areas in which the Philippines is at the bottom. We have the lowest life expectancy at birth among our ASEAN counterparts, the ASEAN 5. We have the highest infant mortality. We have the highest learning poverty rate. We have the lowest tertiary school enrollment rate. We have the lowest human development index. We have the lowest human capital index. We have the highest poverty count ratio. And it is no coincidence that we are also at the bottom for corruption, perception index, the rule of law index, and the ease of doing business index. Well, the bottom line here, the pork barrel is bad news, whether in the form of unprogrammed appropriations or in the form of the DPWH infrastructure budget. It is in the projects are either overpriced and of poor quality, so there is a waste of fiscal funds. And there are large opportunity costs because prioritization is perverted. The prioritization is perverted. The selection of investments are not based on maximizing social welfare. They are based on maximizing private personal gains. Let us all be aware of that. So the development targets may not be met. In the meantime, the Filipino people are robbed, not only at present, but in the future, because these huge, larger budget deficits and the larger debt stock to GDP ratio is going to further constrain the fiscal space later and will constrain the ability of the government to give the people what they need. In other words, Your Honors, strictly from economic point of view, from a rational point of view, the decision is whether to cut down the unprogrammed appropriations or not. And the decision should be always based on, is it worth it? Are the costs greater than the benefits? I feel, given what I have just said, that the costs entailed by the unprogrammed appropriations are so much larger than the benefits, which are contingency, etc., which can be addressed by other things in the budget system. Thank you, Your Honors.
Thank you, Professor Monsod. May we call Senate President Franklin Drilon to make his presentation.
May it please the Honorable Court. I thank the esteemed justices for inviting me to serve as amicus curiae in these landmark petitions involving questions of first impression. Your Honors, while the Constitution provides exhaustive safeguards to ensure that no power remains unchecked. History demonstrates that human ingenuity can elude even the most carefully constructed limitations. And this is what brings us here today. To my mind, and I respectfully submit, this honorable court must settle two main issues. First, whether including unprogrammed appropriations in the budget is constitutional. Second, in determining whether there was grave abuse of discretion, to what extent may this court define the limits of congressional and executive powers under the framework of judicial review? Unprogrammed appropriations, Your Honor, have been a consistent feature of the national budget, with the DBM, or the Department of Budget and Management's data tracing it back to 1989, and statutory authority predating that record as far back as 1971, with Republic Act 6361 making explicit reference to unprogrammed appropriations. Pursuant to Article 6, Section 25, Paragraph 1 of the Constitution, which states that, quote, the form, content, and manner of budget deliberation or budget preparation shall be prescribed by law, end of quote. Congress has consistently integrated unprogrammed appropriations as a component of the General Appropriations Act. It is fair to conclude that until the present controversies surrounding unprogrammed appropriations, successive administrations and Congresses alike have assumed its constitutionality. Save for the Belgica and Araulio cases, the unprogrammed appropriation has remained largely unexamined. Complete clarity, however, after all, is a privilege afforded only by hindsight. Questions on its legitimacy only arose after a marked increase in the unprogrammed appropriation from the National Expenditure Program, or the NEP, to the General Appropriations Act, contrary to the historical parity between the two, with modest to no deviations at all. I submit respectfully, Your Honors, that the unprogrammed appropriation functions as a special appropriation contained in the General Appropriations Law. Consistent with Article 6, Section 25, Paragraph 4 of the Constitution, it specifies the purposes for the appropriation and is released only upon certification of the Treasurer that funds are actually available or will be raised by a corresponding revenue proposal. It serves as a standby authority contingent on revenue windfalls not accounted for on the base in the budget of expenditures and sources of financing, or BESF. In its standard formulation, assuming the conditions are strictly and fully observed, unprogrammed appropriation does not increase the President's recommended budget ceiling. I repeat that, Your Honor, for emphasis. In its standard formulation, assuming the conditions are strictly and fully observed, the unprogrammed appropriations does not exceed the President's recommended spending ceiling. Thus, isolated from implementation concerns and the GOCC funding sweep, unprogrammed appropriation appears to be consistent with the mandate under Section 25, Paragraph 1 of the Constitution. I also submit, Your Honors, that classifying funds as either programmed or unprogrammed is an exercise of the power of the purse. Whether an item is accorded immediate or contingent funding is a deliberate policy decision rooted in the wisdom of Congress to balance immediate operational mandates against contingent fiscal realities. Recent unprogrammed appropriations, however, include funding for regular agency operations, personnel benefits, and other recurring expenses. Foreseen operational costs better included in the programmed rather than unprogrammed appropriations. When the legislative wisdom falters, I concede that the temptation to declare the entire concept of unprogrammed funds as unconstitutional is very strong. We concede that, Your Honor. I humbly submit, however, that the decision to no longer include unprogrammed funds as a component of the annual budget or to strictly define its nature is a matter vested in the Constitution in our political bodies, Congress and the executive branch. And I quote, "The form, content, and manner of preparation of a budget shall be prescribed by law." When the unprogrammed appropriations has been a consistent feature of the General Appropriations Act, the special provision on their release have undergone several iterations throughout the years. In the 1989 General Appropriations Act, the special provision states that, quote, "No item may be programmed until after the first quarter of 1990, when the Development Budget Coordinating Committee shall determine and certify that revenue targets of government have been met," end of quote. In the 1991 General Appropriations Act, the release of funds were conditioned on excess revenue collections over the BESF, citing Article 7, Section 22 of the Constitution. The special provision further states that no amount shall be funded out of savings generated from the programmed items in the General Appropriations Act. The current iteration, Your Honors, of the special provisions of the unprogrammed appropriations first appeared only in 2015, no longer tying the release to the general excess over BESF targets, but upon A, excess collections from any identified non-tax source. And I underscore the word any, meaning, even if the general revenue program is not met, if any item of the revenue program is exceeded, then that gave the authority to fund an unprogrammed appropriation. To me, that is a very wrong and malicious interpretation of this provision of law. As early as Araulio versus Aquino, the executive has maintained that excess collections should be measured per individual BESF revenue source, a view made explicit in the 2015 GAA and thereafter. Despite being a respondent in that case, I respectfully invite this honorable court to revisit its pronouncement on unprogrammed funds. To release unprogrammed funds, the unprogrammed funds simply because there was an excess as to one source of revenue would be an unsound fiscal management measure because it would disregard the basic budget plan and foster fiscal deficits in contravention of the government's surplus budget policy. Before the present petitions, the phrase, quote, "funds actually available," end close quote, under Article 6, Section 25, Paragraph 4, has not been defined, and releases based on excess from a single source was presumed to be a valid exercise of of the Treasurer's certification. We emphasize this and invite this honorable court to give special attention to this practice and provision in the General Appropriations Act. My humble submission that to preserve the unprogrammed appropriation as a valid fiscal tool within the General Appropriations Act, it must be strictly sourced from funds annually available, triggered by genuine windfalls, measured against the aggregate of the President's original BESF revenue targets in line with Article 7, Section 22 of the Constitution. Ideally, the program budget should be completely covered by funding before any excess is declared. If one source exceeds the target, while the total national budget is below the BESF aggregate, then strictly speaking, no funds are truly available for release. To rule otherwise will result in the absurd situation where the unprogrammed contingencies are funded ahead of the programmed mandates. Using the aggregate standard also cuts the temptation to fill the unprogrammed appropriations with pork barrel projects, knowing that funds will not be easily released. I maintain, Your Honors, that unprogrammed appropriations are not inherently unconstitutional. However, when the low threshold of excess revenue funds the inflated list in the unprogrammed appropriation, including those moved from the program budget, the funding appears to be no longer contingent, but almost certain. It also loses its character as a special appropriation and instead operates as a disguised general appropriations that may serve to expand the footprint of the original budget submitted by the President. In this perfect storm, Your Honors, the violation is not found in the text of the law, but in the arithmetic of its execution. Thank you very much, Your Excellencies.
Thank you. Okay. May we call Honorable Benjamin Jokno to make his presentation.
Chief Justice, Your Honors, good morning, still morning, right? Allow me to present my comments on the pending Supreme Court petitions questioning certain provisions on unprogrammed appropriations in the 2024, 2025, and 2026 General Appropriations Act. As former Senior Undersecretary and Secretary of Budget and Management, I have prepared 13 of the 39 post-EDSA 1 revolution national budgets, including the first and only budget under the Freedom Constitution. Notably, the 1987 budget already contained unprogrammed appropriations. From 2026, rather from 2005 to 2026, Congress approved unprogrammed appropriations exceeding those proposed by the President only 5 times. in 2010 under President Arroyo, in 2022 under President Duterte, and from 2023 to 2025 under President Marcos Jr. The increases over the last 3 years, however, have been particularly large. So those are encircled there. Back, please. The blue line is the one in the NEP, and the red line is the one approved by Congress. This is not to argue that Congress may increase the unprogrammed appropriations as requested by the executive. This is only meant to reflect the monumental abuses done by Congress during the last 3 years, 2023, 2024, and 2025 national budgets. By design, unprogrammed appropriations serve as standby appropriations. The budget planning, preparation, and authorization process is complex and time-consuming. For example, preparation for the 2026 budget began as early as January 2025 with a budget call. Now, some foreign-assisted projects, which may be seen as the most senior of all budget items since they undergo a series of studies, are considered but not completed or approved a year prior to the start. FAPs are among the most rigorously evaluated budget items. Let me repeat that. The foreign-assisted projects are among the most rigorously evaluated budget items. They undergo pre-feasibility study, feasibility studies, detailed engineering, and a review of the internal rate of return threshold by the NEDA Investment Coordination Committee. Now, despite their merit, these projects risk delay due to the constitutional requirement that no money shall be paid out of the Treasury except in pursuance on appropriation made by law. So delays in the implementation are costly, and they result in the payment of commitment fees to multilateral financial institutions. That's why we have standby appropriations for foreign-assisted projects. Now, the national budget is the most consequential piece of legislation enacted by Congress. In a tripartite system of government, the executive branch is generally understood to have a comprehensive view of national priorities, better access to domestic and global data, superior assessment of bureaucratic capacity and revenue potential, and a broader perspective and better appreciation of deficit levels and debt sustainability. Congress, which holds the power of the purse, directly represents the people. No offense meant to our former legislators here, but legislators often have a more localized, particularistic view, focusing on deliverables for their respective constituencies. And so this may be the rationale for the constitutional provision that Congress may not enact a budget larger than what was proposed by the President in the budget of expenditures and sources of financing. Now, let me go directly to the unprogrammed appropriations. The size of the unprogrammed appropriations is driven mainly by the number and the amount of foreign-assisted projects not included in the proposed budget, but likely to become effective during the forthcoming fiscal year. It also depends on the likelihood that actual revenues will exceed projections in the BSF. Historically, deviations between projected and actual revenues have ranged from negative, in other words, we have actually under-collected rather than over-collected, 19.2%. That happened during the COVID years, understandably, to 10.6% in 2021. There is a wide variation in unprogrammed appropriations as a share of the total budget across administrations. It was highest under President Marcos Jr. at 9%, and lowest under President Duterte at 3.9%. Finally, on whether Congress validly increased or earmarked funds for the Road Users Fund by reallocating items in the 2025 General Appropriations Act. The Department of Public Works, full disclosure, I worked for the abolition of the Road Users Board. It was a good law, but the way it was implemented was anomalous during the GMA years. So I moved for the abolition of the Road Users Fund, Board rather, but the fund remains. And so under the current system, the Department of Public Works and Highways alone determines the available road users fund for the fiscal year, the required expenditures for road maintenance, and that, of course, depends on a formula, the length of the existing roads, the need for maintenance every 5 years for good roads, and maybe annual for the poor roads, and of course also the operational capacity of the DPWH. This amount is incorporated by the Department of Budget and Management into the President's budget, with a commitment of the DPWH Secretary during the Cabinet meeting, approximately 1 month before the opening of Congress. That is the last Cabinet meeting to tackle the budget. The DPWH Secretary is committed to the President as to the amount of that road users fund. And this is prior to the BSF and the National Expenditure Program. Given this process, the basis for increasing allocations beyond what was proposed by the executive is unclear. And so the next table will show you the deviations. The President proposed in 2022 15.192 billion. Well, Congress reduced it. That's in accordance with the Constitution. Congress may not increase, but may decrease. In 2023, the President proposed 15.192 billion. Congress increased it to 21.231 billion, or 39% increase. 2024, the President or the DPWH Secretary, and approved by the President, asked for 15.2 billion. Congress increased it to 24.5 billion, or 61.2% increase. In 2025, 16.755 billion, that was the request of the President. Congress increased it by 107.4% to 34.748 billion, equivalent to 33.4 billion for the 3 years. That is approximately equivalent to 66,800 school rooms at $500,000 per school room. In my view, these increases is inconsistent with the constitutional provision that Congress may not increase the appropriations recommended by the President for the operation of the government as specified in the budget. Thank you very much.
Thank you. Okay. May we call Professor Secretary Abad for his presentation.
The Honorable Chief Justice, Senior Associate Justice, Associate Justices, good morning. May it please the Court. The question before this Honorable Court do not concern merely the validity of particular provisions in an appropriation law. They go to the heart of the Constitution's design over the public purse and the system of accountability that it commands. The 1987 Constitution, at its core, is an accountability constitution. It structures the national budget not simply to allocate resources, but to ensure that public funds are raised, authorized, and spent under conditions of transparency, discipline, and institutional control. At the center of that structure is a fundamental requirement that the national budget must be a financed fiscal program. Under Article 7, Section 22, the President submits to Congress a budget of expenditure and sources of financing, the BESF. The submission is not a formality. It is the constitutional anchor of the appropriation process. It reflects a basic but indispensable principle that expenditures must correspond to identified and available sources of financing. This structure is reinforced by a further constitutional restraint, the budget ceiling. Congress may not increase total appropriations beyond what the President has proposed. Taken together, these requirements ensure that the budget is not an open-ended wish list, but a coherent fiscal program grounded in reality. The constitutional process is thus carefully sequenced. First, the executive formulates a financed fiscal program. Second, Congress exercises the power of the purse within that program. Third, the executive implements the budget as enacted. The sequence, Your Honors, is not procedural convenience. It is a constitutional safeguard designed to preserve both fiscal discipline and institutional accountability. And program appropriations must be understood within this constitutional structure. In practice, the Philippine fiscal system operates under persistent deficit conditions. Over the past 4 decades, budget surpluses have occurred only briefly during the administration of Fidel V. Ramos, and even then, only in modest amounts. More importantly, Your Honors, revenue targets have been exceeded in only a handful of years. This means that in the ordinary course, the conditions required to validly trigger and program appropriations do not exist. As this court made clear to Arroyo versus Aquino III, excess revenue, quote unquote, must be determined holistically based on total revenues relative to total projections in the BESF, not on isolated gains from particular sources. Accordingly, under normal fiscal conditions, unprogrammed appropriations are not meant to operate. They are by design exceptional. There have been instances, however, where unprogrammed appropriations were activated, not on the basis of genuine fiscal surplus, but through fragmented and selective interpretations of revenue excess. Prior to this court's clarification in Arroyo, the position was taken that excess collections from individual revenue sources, such as GOCC dividends or non-tax revenues, could justify releases. This court rejected that approach. It held that revenue must be assessed in its totality. Isolated gains cannot create artificial surpluses. And to treat them as such is to risk unsound fiscal management, increasing borrowing and expanding the deficit. Subsequent rulings, including Pimentel III versus House of Representatives, further clarified that funds earmarked by law do not constitute disposable revenue. But even assuming, Your Honors, valid activation, the deeper constitutional issue remains. In a situation where deficits are the norm, additional revenues, when they arise, are rarely sufficient to fund all unprogrammed appropriations. The reality forces three decisions: which appropriations will be funded, which will not, and in what amounts. These are not technical decisions. They are allocative judgments about public funds. Yet, by that stage, the appropriations law has already been enacted. These decisions, therefore, occur during budget execution and are made by the executive. In practical terms, Your Honors, the executive determines which among legislatively authorized appropriations will actually become operative expenditures. That, Your Honors, is the constitutional problem. It is not merely a matter of administration. It is a displacement of accountability. The Constitution assigns to Congress the authority to decide which public purposes receive funding and to what extent. But when funding is insufficient, that decision effectively migrates from legislation to execution. Recent practices raise an even more serious concern, Your Honors. When unprogrammed appropriations are expanded beyond fiscal limits and treated as readily activatable, they risk becoming not merely contingent spending authority, but a mechanism for circumventing constitutional restraints. In particular, they raise questions as to whether the budget ceiling itself is being observed or effectively bypassed. And when allocations depend on discretionary activation, they risk becoming opaque instruments of spending, weakening transparency and undermining the Constitution's accountability safeguards. It is sometimes argued, as was here, that unprogrammed appropriations are necessary for flexibility. But the Constitution already provides that flexibility, and does so without sacrificing accountability. Under Section 6, Article 25, Section 25, subsection 4, Congress may enact supplemental or special appropriations supported by funds actually available or by revenues to be raised. This mechanism preserves flexibility while ensuring that decisions on public spending remain within the legislative process where the Constitution places them. Your Honors, the constitutional rules governing the national budget are not mere technicalities. They are structural safeguards designed to preserve the separation of powers and ensure accountability over public funds. This court has consistently upheld these principles in Belgica versus Executive Secretary and Arroyo versus Aquino. In conclusion, the Constitution already provides a complete framework for fiscal governance. The issue before the court is not whether flexibility is desirable. It is whether that flexibility may operate outside the constitutional structure that governs the budget. The Constitution allows flexibility, but it requires that decisions on how public funds are spent remain within the legislative appropriation process and do not migrate into the execution stage of the budget. To allow otherwise is not merely to relax a rule, it is to reconfigure the allocation of power over the public purse. And that, Your Honors, is a constitutional question of the highest order. Thank you.
Thank you, Secretary Abad. Considering it's 5 minutes after 12, the session is suspended to resume at 1:30.